to introduce our speaker, Jeffrey Baird. Mr. Baird is chairman of the healthcare group at Brown and Fortunato, PC, a law firm based in Amarillo, Texas. Mr. Baird represents pharmacies, HME companies, and other healthcare providers throughout the United States and works closely with governmental agencies. He is a graduate of the University of Tulsa College of Law and is board certified in health law by the Texas Board of Legal Specialization. And with that, I'll turn it over to you, Jeffrey.
Thanks a lot, Tracy. Hey, folks, this is going to be the highlight of your week because for the next hour, you get to listen to an attorney, and all I can tell you is that that is as good as it gets. But all kidding aside, it's an honor for me to be able to spend an hour with you, and it's certainly an honor for me to be able to present this webinar on behalf of American Associated Pharmacies and Tracy and her team. They are the best of the best. They offer just absolutely unprecedented services to pharmacies. And so this is a lot of fun for me, and I'm just grateful that Tracy and her folks have asked me to speak. I'm going to talk for about 45 minutes. I've got a zillion slides here. There's no way in God's green earth I'm going to make it through all the slides. But you'll find that the slides are very detailed. They read like a John Grisham novel. And I do that for a reason, which is that after this webinar, you will have some reference material that you can just read afterwards, which hopefully will be of some use for you. And also go ahead and start sending your questions in to Tracy. This is as cheap as you're going to get an attorney. And so ask away, and hopefully I'll have the answers. Now, let's see if I get my slide to work here. 1 second. Try it again. Let's try this way. Oh, there we go. I love technology. Try it again. I'll get there yet. Let's see here. There and there, I think. Okay. Now, at the end of the day, let's try to put things into perspective. Working with doctors, trying to get referrals from doctors. There are two reasons why we want to have a good relationship with multiple physicians. One of which is that all of healthcare is being pushed away from the fee-for-service model and into a collaborative model, coordination of care model. And to do that, we as pharmacies have to work closely with doctors and hospitals and RTs and PTs and others so that we get a good result for our patients. In addition to that, we certainly, as pharmacies, we are dependent on prescriptions, and so we need referral sources. And and a referral source can be anybody. It can be a doctor, it can be a nurse, it can be an RT, it can be a hospital discharge planner, it can be a taxi cab driver, and it can be a potted plant. But here we're going to focus on doctors. But we certainly want to develop relationships with doctors so that we can receive referrals. Now, what we have to understand is that as pharmacies, we live in the proverbial glass house. If we're doing something we shouldn't be doing, somebody knows about it. And we have to, as pharmacies, we have to make sure that we follow a number of federal and state anti-fraud laws and other regulations. And if we don't, then bad things can happen to us. We have out there an animal that's called a qui-tam, Q-U-I-T-A-M, or whistleblower. And that is if we have an employee or just somebody else that knows our business that determines that we're messing up, we're committing some type of fraud or stark violation or something, then that employee or person can go to an attorney and say, let's file a lawsuit against Jeff's Pharmacy, Inc. and Jeff Baird individually under the Federal False Claims Act because of these fraudulent things that Jeff's Pharmacy is doing. That lawsuit goes under seal. The only people that know about it is the Department of Justice. They look at it, they investigate it, and then they may take it over later and say, okay, we'll take it from here. And so, again, we just can't hide anything. We really have to strive to be as pristine as we can. Well, from a federal standpoint, we have the federal anti-kickback statute. It's a criminal statute. If we violate it, we end up going to Club Fed. And all this means, what the statute says is that just pharmacy cannot provide anything of value, money, trip to Cabo, golf clubs, you name it, to a doctor or to a nurse or to a discharge planner or to a home health agency or to a taxi cab driver or to a kindergarten teacher or to a potted plant, in exchange for that person referring to Just Pharmacy a federal health care program patient, such as a Medicare or Medicaid patient or a Part D patient, excuse me, or arranging for the referral of such a patient to Just Pharmacy, or even for recommending the purchase of a product that's covered by any federal health care program. Now, I could go, I could speak for the next 3 hours just on the federal anti-kickback statute. Just be aware it's very broad. And in fraud and abuse land, we have to understand that if our brain tells us one thing and our stomach tells us something else, we ignore our brain, we trust our stomach. Okay. When it comes to dealing with physicians, let's see here if I can get my second. There we go. Almost. I love technology here. Let's see if we can get this to work. There we go. Almost. Yeah, Stark. Okay. The federal anti-kickback statute is a criminal statute. There's another federal statute called Stark, S-T-A-R-K, that's named after the former Representative Pete Stark out of California. And Stark's been around for a long time. While the federal anti-kickback statute applies to doctors, nurses, discharge planners, kindergarten teachers, and potted plants, Stark only applies to doctors. And essentially what Stark says is this: if Dr. Jones has an ownership interest in Just Pharmacy, or if Just Pharmacy is paying some money to Dr. Jones, or if Dr. Jones has any other type of financial or ownership interest with Just Pharmacy, then Dr. Jones cannot refer Medicare or Medicaid patients to Just Pharmacy. That's what Stark says. Now, Stark has a whole bunch of exceptions. And again, to kind of backtrack, you've got the federal anti-kickback statute has only one or two exceptions, but has a whole bunch of safe harbors. Stark, on the other hand, has no safe harbors, but has a whole bunch of exceptions. So, I'll tell you, Tracy, my slides are not advancing easily. Let's see here.
And there seems to be a bit of a delay.
Yeah. What can you advance the slide for me?
Absolutely.
Right. See what happens. See if you're going to have the same problem that I've been having. Okay, tell you what, I think I might, for a while, I might have you advance the slides for me. I'll just tell you when to move on to the next slide. Is that okay?
Sounds perfect.
Okay. Now, Stark has a whole bunch of exceptions out there. And again, we could do an 8-hour webinar just on Stark. But for our purposes, the exception that we're going to focus on is what's called the Stark non-monetary compensation exception. And essentially what this says is that, go ahead and go to the next slide, Tracy. But essentially what this says is that Just Pharmacy can spend up to a certain amount each year on a doctor for golf games and food and things like that. And that amount started off originally at $300. Now for 2020, it's $423. And so we could spend that much on Dr. Jones. Now, if Dr. Jones is part of a 5-physician group, then we could spend up to $423 on for each of those physicians, for each of those 5 physicians in Dr. Jones's physician group. Now, what's interesting, and I know I'm kind of going off track here, and I'll get back to the slides here in a second, but this exception, $423 in 2020, applies to Dr. Jones, but it does not apply to his nurses and staff. And so the question becomes, okay, so if I can spend up to $423 in 2020 on Dr. Jones for food and golf games, things like that, does that exception also apply to his non-physician staff? And the answer is no, because Stark only applies to doctors, does not apply to the staff. So the question becomes, well, what can I do with the staff? And the answer is, well, Stark doesn't apply to the staff, but the anti-kickback statute does, meaning then that let's just be smart about it. Can we drop off a box of Krispy Kreme donuts to Dr. Jones' staff once a year? Well, I guess you could argue with that a $4 box of donuts is something of value to a referral source, but hence we have a violation of the anti-kickback statute. But who cares? I mean, that's kind of, come on, they're donuts. Nobody cares about that. And so when it comes to doing stuff for the doctor's staff, let's just be smart about it. Donuts once a month, sure. Maybe cater a meal from Pizza Hut or Jason's Deli twice a year, sure. Donuts every day? No. Catering lunch every week? Of course not. Let's just be smart about it. Now, so we've talked about as far as doctors are concerned, we've talked about the federal anti-kickback statute, and we've talked about Stark. Let's take that, put it aside. Let's just assume that Just Pharmacy doesn't do any federal stuff at all. I don't do any Part D. I don't do any Part B, nothing like that. Let's just say I do straight cash and maybe some commercial insurance. We have to be aware that each of the 50 states has each state has its own anti-fraud laws, and these are similar to the federal laws. And so if we're going to do a deal with a doctor or a hospital or a lab or something, we need to look at it not only under the federal laws, but then once we satisfy ourselves that we're okay under the federal laws, we put that aside and we say, okay, how are we under state laws? And so we just need to be aware of that. And in addition to state anti-kickback statutes, things of that nature, every state has a Medical Practices Act, or MPA, that has specific laws pertaining to physicians, and every state has a pharmacy code, CODE, that has laws specific to physicians. Okay, Tracy, next slide. Now, let me give you some examples here. In law, who was it? I think it was Justice Potter Stewart back in the 70s, U.S. Supreme Court Justice, I think this is right, gave a definition of pornography, and that is, you know it when you see it. Or said another way, this is the classic duck test. It looks like a duck, sounds like a duck, walks like a duck, it's a duck. It doesn't, if your brain tells you, yeah, I can justify something is fraudulent, but if your stomach says, I hurt, you trust your stomach. So what does that mean as far as a clinical study is concerned? I'm perfectly okay with a pharmacy getting involved in a clinical study with one or more physicians as long as it passes the smell test. Is the clinical study operated by a hospital or a medical school? Is it overseen by an institutional review board, IRB? If it is, we're probably in pretty good shape. If, however, the clinical study is just a subterfuge or a sham meant to get money from us as a pharmacy to some referring doctors, we got a kickback. And so I think just like the definition of pornography is, when you see it, the definition of a valid clinical study versus a sham clinical study is, you know it when you see it. Okay, next slide, Tracy. Now, Just Pharmacy. Let's assume Dr. Jones is a referral source, but I want to pay him some money to be my medical director, and let's assume I really need a medical director. Can I do that? Can I pay money to a referral source to serve as my medical director? Well, automatically, we're triggering the anti-kickback statute and Stark if we pay Dr. Jones some money, even though he's giving us legitimate services. So right off the bat, we have a problem. But then we have a safe harbor to the anti-kickback statute, and we have an exception to Stark. They essentially say the same thing, which is that as long as we have a legitimate need for Dr. Jones to be our medical director, and as long as we're paying him fair market value for actual services rendered, as long as we sign a written medical director agreement with a term of at least 1 year, as long as the money we pay is fair market value, then we're just fine. And so what I like to, I'll give you an example. Dr. Jones agrees to be a medical director for Just Pharmacy. He's going to give me 5 hours of his time per month as my medical director. His time is worth $300 an hour, and so I'm going to commit to pay him exactly $18,000 a year, or $1,500 a month, or 5 times $300 per hour. Now, here's where it gets kind of squirrely. Let's say that I like this medical director arrangement so much with Dr. Jones, I want to do the same thing with 4 other doctors who are also referral sources. No, we can't do that. Why? Because we don't need them. It doesn't pass the smell test. If it looks like a duck, walks like a duck, sounds like a duck, it's a duck. Okay, Tracy, next slide. Oh, next slide, please. Now, education workshops. I'm perfectly okay. Okay, we're good. I'm perfectly okay with a pharmacy sending an employee to the doc's office to educate the physician staff. I'm okay with sending an employee to the physician's office to help educate the physician's patients. Okay, next slide. Now, can we sponsor the physician as a speaker? And the answer is sure, if we do it the right way. In other words, let's say that, I don't know, I'm a specialty pharmacy and I don't know, I specialize in IVIG. And so I want a physician to give an education program to FPs, family practitioners in the community that also in their practice they do see their share of peds. And so I want to pay Dr. Jones to who specially, let's say he's about to go way ahead of my skis now, over my skis, but he's infectious disease doc, and I want to pay him to put on, and he's a referral source to me, and I want to pay him to put on an education session for FPs and general internists in the community. Can I do that? And the answer is sure, as long as what I pay him is the fair market value equivalent of his services. In other words, I'll pay him for his prep time and the time that he gives to present this thing. I'm not going to pay him a lot of money, but I'm going to pay him just for what his services are worth. That's okay. But if you look at the trade publications out there and look at Department of Justice releases, you're going to see a whole bunch of pharmacies and labs and doctors and everybody else that have really gotten into trouble because these are sham speaker agreements, where in reality what the pharmacy or lab or manufacturer does is pay a whole lot more money than what they should have to a doctor that's presenting something that's really not of any use to anybody. Okay, next slide. Now, Dr. Jones is a big referral source to Just Pharmacy. Can Just Pharmacy, and let's say Dr. Jones owns a 10,000 square foot building. Just Pharmacy can go in and rent 2,000 square feet and pay rent to Dr. Jones. So now I'm paying rent to a referral source. I can do that so long as I comply with a safe harbor to the anti-kickback statute and comply to an exception to Stark. And these say the same thing, which is Dr. Jones here in Toledo, Ohio, fair market value rent is $12 per square foot. That's what I'm going to pay you, $12 per square foot. If I pay Dr. Jones $18 per square foot, we've got a kickback and a Stark violation. Okay, next slide. Now, we can play, an employee liaison is when Just Pharmacy places an employee in a physician clinic or in a hospital or in a wound care center or in a SNF. And the purpose of the employee is to help facilitate the transition of services from that facility over to just pharmacy upon discharge of the patient. I can do that. That's okay. Where pharmacies and others get into trouble is, let's say, just pharmacy places an employee liaison over into a SNF, large SNF, and my employee liaison steps over the line and starts performing services that SNF normally would have to pay its own employees to perform. Then now Just Pharmacy is saving money for a referral source. That saving of money is something of value, hence a violation of the anti-kickback statute. Next slide. Next slide. Next slide. Okay, next one. Now, there you go. Let's look at two scenarios, and then I'm going to kind of jump ahead some other stuff here in a minute. Dr. Smith, because I've been talking about Dr. Jones. We'll use Dr. Jones here. Dr. Jones refers patients to Just Pharmacy, and Dr. Jones comes to me and says, "Hey, Jeff, I need for you to help offset some expenses. I've got a continuing education program in Palm Springs. Will you help me out here?" Now, you might think, well, okay, maybe I can do so if I spend up to $423 in 2020 to help send him to Palm Springs. And the answer is no, can't do that. Why? Two reasons. Number one, the non-monetary compensation exception, $423 in 2020, is for things that can be touched and felt, food, golf game, things like that. It cannot be equivalent. It cannot be some type of monetary equivalent, such as helping offset expenses. Secondly, the non-monetary compensation exception only kicks in or does not apply if the doctor is the one that's actually requesting the gift. So that wouldn't work. Scenario number two, though, let's look at the next slide. Keep going. Okay. Now, what you're going to find, Tracy, is I pretty much ignore my slides, so kind of bear with me. Scenario number two, if the doctor said, let's say that I, as Just Pharmacy, let's say I'm pretty good size. I'm a specialty pharmacy, and I'm sending drugs into multiple states. And I want to have a conference for key employees, let's say down in Boca Raton. And let's say Dr. Jones is a big referral source. And I want him to speak at my conference to my employees. Can I pay him to do that? And the answer is sure I can. As long as what I'm paying him is fair market value, I'm not overpaying him. Okay, next slide. And there we go. Now, we have this animal out there that's called, or three animals, called annual wellness visits, remote, and number one, number two, remote patient monitoring, and number three, chronic care management. And basically, that's where, Medicare pays money to doctors for preventive maintenance. In other words, instead of their patients getting deathly sick and going to the ER on a Friday night, instead, doctors try to monitor their patients so that they don't get that sick. Well, if a pharmacy assists a doctor in doing this, that's okay as long as the doctor pays fair market value compensation to the pharmacy. If the pharmacy is assisting the doctor for free, then that's something of value to a referral source. Hence, we got a problem. Next slide. Okay, let's switch gears. Next slide. PBMs. Now, first of all, let's make sure we're all on the same page here. And I'm not going to even talk about the slide right now. I'm just going to give you an overview. Our law firm works with a whole bunch of pharmacies in all 50 states. at any given time, we are representing a number of pharmacies that are getting hammered by PBMs. PBMs are coming in, they're auditing, they're investigating, they're terminating contracts, they're doing all kinds of bad stuff. They're withholding money. And we have to understand, at least as of today, that PBMs have the power of God and have very little accountability. That's changing, which I'll discuss with you in a second. But if just pharmacy gets involved in a spitting contest with a PBM, then I just have to realize that this is an unequal bargaining position. The PBM has my money. And it doesn't matter if the PBM is right or wrong, it's got my money. And if it doesn't pay me my money, I have to close my doors. And so we just have to realize that there is an unequal bargaining position. Therefore, and by the way, right now I'm covering a bunch of slides that I'll just kind of blow through here in a little bit. Here at Brown Fortunato, when a pharmacy comes to us and says, hey, we just got termed, or we just got this notice letter, or something's happening with ESI or CVS Caremark or whomever, then our approach as a law firm is not to be combative, is not to be adversarial. The PBM's got a whole lot more money than our pharmacy client does, and the PBM can very easily lawyer up. And it controls our client's money. So it's an unequal fight. It's like bringing a knife to a gunfight. And so we get that. And so what we try to do, and we've had success with this, not always, but we've had some pretty good success, is when a PBM is coming after a pharmacy client of ours, that we try to come up with a win-win arrangement. We'll try to give the PBM a victory, but then also give enough of a victory to our pharmacy clients so that it can live to fight another day. In other words, we rather than being zero-sum game, we try to work out the solution. We try to solve the problem. Our experience has been that if an attorney becomes really adversarial to the PBM, usually the pharmacy is going to lose. And so it's important to work in a conciliatory manner with PBMs. Now, we just have to understand a couple of basic points. And again, I'm covering a bunch of slides right now. And that is the contracts that we have with PBMs can be terminated by the PBMs without cause, usually upon 30, 60, or 90 days notice. And so it's, if we end up having a bad relationship with the PBM, it can just term us. And we just have to understand that. We also have to understand that the contract that we have with the PBM might be, 25 pages long, but it's going to incorporate by reference a bunch of other policies and procedures of the PBM that are not contained in the contract. That's called collateral incorporation. And so we just have to be aware of that. Next, and then go ahead and go to the next slide, Tracy, is that we as pharmacies, we are given questionnaires by PBMs every year or two or three where we have to spill our guts. And when we do that and we fill out those questionnaires, we really have to be honest. For example, if the questionnaire says, let's say that we are on the PBM's retail panel, and the questionnaire says, is more than 20% of your business mail order? Well, you know exactly where the PBM is coming from, because the contract that we have with the PBM probably says no more than 20% of our business can be mail order. And so it's asking us to confirm that not more than 20% of our business is mail order. Well, let's say that 60% of our business is mail order. Well, human nature is we sure like, we might be inclined to lie and say, oh, no, not more than 20% is mail order. Well, you can't do that because for all kinds of obvious reasons, one of which is we're going to be found out. And so with these questionnaires, we have to be as honest. We just have to be absolutely honest. Now, actually, let's go back. Let's go back to the previous slide, Tracy. There you go. Now, we just have to understand that, and here's again, it gets interesting. Back in the old days, when a PBM audits were pretty simple. They asked three questions. Did you get a prescription? Yeah. Did you send out the proper drug in accordance with the prescription? Yes. And did you properly bill for that drug? Yes. Those were the basic questions. Well, now PBM audits, PBMs are almost acting like the Office of Inspector General of the Department of Justice. So because they're coming in and being really intrusive in their questions, particularly the questionnaires. They want to know the extent of our mail order. Well, that's obvious because if we're a retail pharmacy, then ESI doesn't want us competing with its mail order business. Secondly, we had a bunch of pharmacies several years ago, compounded a whole bunch of pain scar creams and just billed the heck out of PBMs and TRICARE, and of course that blew up. And so now PBMs really are down on compounding, so they greatly restrict the compounding that we can do. If a pharmacy is sending drugs out to various states, it's got to have out-of-state pharmacy licenses in those states. Well, there's going to be another question in the audit. Co-payments, and again, I'm covering a bunch of future slides here, so just kind of bear with me. If our contract with the pharmacy says, our contract with the PBM, says that we must make a reasonable effort to collect co-payments, and that we can only waive a co-payment if the patient shows us that he or she has an inability to pay. If we are routinely waiving co-payments, then that's going to be a violation of the contract, and we can be terminated. And so they're going to ask us about co-payments. Do we have a co-payment policy? If so, what is it? What percentage of co-payments have we been collecting? This last thing is a big deal. Look at the fifth check mark there. And I could talk for hours on this. Bottom line, just pharmacy. I'm greatly simplifying this, but I can pay commissions. Actually, let me back up for a second here. If Joe Smith is a marketing rep for Just Pharmacy, if Joe Smith is a W-2 employee, full-time or part-time, then I can pay him a base salary plus bonuses and other distributions based on a number of factors, including the amount of business he generates for Just Pharmacy. We can do that. However, if Joe Smith is a 1099 independent contractor and I pay him commissions, we have a felony. Why? Because I'm giving something of value to somebody, Joe Smith, who is arranging for the referral of patients to Just Pharmacy, some of which patients are covered by a federal health care program. And so we as pharmacies cannot pay commissions to 1099s. We can pay production-based bonuses to W-2s. Well, the PBM is going to ask that question. And so we just need to be aware these five arrows, these five check marks are kind of the hot button issues right now that PBMs are looking at. Okay, Tracy, next slide. Hopefully.
Sorry, there's a significant delay between when I advance and when it displays.
No, I think what happens is when I stay on a slide for a while, then it delays. Hopefully you get to work. Let's see if I can get to work. There we go. Okay. It stopped you there. Okay. Now let's go back to the previous slide. There we go. Now, it's important throughout the course of the year for us internally to conduct self-audits. hopefully these will be the canary in the mine shaft that will tell us if some problems arise, if there are some problems that are arising. It's also smart once a year to have an outsider come in and do a mock audit because the outsider is going to be a lot more objective. Okay, next slide. Oh, good. You're there. Yeah, you're good. It's important to have, I just call it an audit response team or ART. And basically, we need to train some employees on how to respond to a PBM audit. We've seen nightmares where a PBM will email, fax, or send a hard copy letter to Just Pharmacy and say, we need to look at a bunch of stuff. And a low-level employee receives that communication and does nothing with it, and it does not make its way of the food chain to the owner until after deadlines are passed. And by the time that happens, then life gets really difficult. And so it's important that we have, we train people on what to look for in terms of phone calls, in terms of emails and faxes and hard copy documentation, but also what happens if a PBM just has somebody walk through the front door. Let's just not be surprised. Okay, next slide. What we've done before is we'll actually have mock drills where the owner of the pharmacy will ask our law firm to actually pose as a PBM auditor, and let's just see how well trained the employees are. Okay, next slide. Okay, next slide. Okay, we talked about that. Next one. Yeah, just be aware, deadlines are sacred. When we see a deadline, boy, let's etch it in blood on the wall. Let's just make sure that we know exactly what it is. Having said that, most PBMs will grant at least one extension. You know, if a PBM comes in and gives us only 20 days to do something, we don't have enough time, then usually the PBM will grant at least one extension. Okay, next. Okay, next. Okay, let me just kind of, attorneys are good for something. Now, this is self-serving, and so bear with me. But when we get hit with a PBM audit or investigation, it's important to hire a healthcare attorney. Your local real estate lawyer is not going to have the slightest idea as to what's going on. But you need to hire a healthcare attorney, and here's the reason why. It's not that we're any smarter than anybody else, but we're trained to, we're trained to help pharmacies do this, to help pharmacies respond, and we're objective. Human nature is such where if an outsider comes in and criticizes me or criticizes the way I practice law, human nature is that I'm going to be instantly defensive. I'm not going to be as objective as I would like to be. Well, likewise, with if a PBM comes in and audits or investigates Just Pharmacy, and I own Just Pharmacy, then I may not be real objective. I may be defensive. I may need a healthcare lawyer to pat me on the back and say, "No, Jeff, you need to calm down, and let's just work the problem. Don't take this personally." In addition, next slide. In addition to that, okay, next one. There we go. The attorneys are trained to help put together documentation in an organized, logical way. Attorneys are trained to help the pharmacy send everything in. And often what we do is we will ghostwrite an explanatory letter. So you've got Just Pharmacy, and the attorney is now has assisted my pharmacy in putting together the documentation. But then when we send it in, we want to Just Pharmacy is going to sign a letter that says, "Okay, here's an explanation." That letter should be ghostwritten by the attorney because, again, he or she is trained to be able to tell that type of story. Okay, next slide. Okay, next. You know, one of the things that we need to understand is what is the PBM focusing on, and we've talked about that. You know, in fact, go to the next slide, Tracy. You know, there not only is the PBM looking at documentation, but also looking at other things that we're doing. Okay, next one. Okay, let's go on ahead. Let's get away from PBMs now, and let's go to the next major section. Let's kind of keep flipping through the slides, Tracy, until we get to CBD. Oh, you're good. Okay. I've got a section there. Actually, let's go to I think it's FDA. Let's go to FDA. That's the next one. I think it's right. No, CBD. Yeah, the next one is CBD. Then after that's FDA. I'll tell you what, while she's finding slides on CBD, I'll go and start talking about it. I've given you a number of slides on, it's kind of the, here we go. Yeah, second. Here we go. Okay, cannabidiol. The hot topic out there right now is cannabidiol or CBD, and I've given you a whole bunch of slides on that. And let me just tell you essentially what they say. We have a 2018. It's called the Farm Act, in which the federal government has, again, you'll find this in your slides. Yeah, the Farm Bill. It's called the Agriculture Improvement Act of 2018. Farm Bill passed in December of 2018. And it establishes a category of cannabis, which is hemp, defined as cannabis containing 0.3% or less of THC. And there we go. And so what the Farm Bill is saying is that if you're going to be, from a federal standpoint, if we're going to be selling CBD that comes from hemp that has 0.3% less or 3% less of THC, which is what makes us high, then from a federal standpoint, we're going to be okay. But even then, you have the FDA that says, well, that may be very well and good, but you as a seller of CBD, say CBD oil, you cannot advertise or market that this is going to cure cancer or cure migraines or cure diabetes or things like that. You have to be, you can't, you just can't go out and hawk it like you're some, like you're some 18th magic elixir salesman back in the 1860s. And so we have this limited federal approval for certain types of CBD made from hemp with a very low quantity of THC. Now, take that, you put it aside. We also have 50 states out there, and every state now. Oh, good job. Okay, let's go to yeah. And here, interesting. This slide here talks about the difference between CBD and THC in marijuana. CBD does not create a high. Pot does. Okay, next slide. And here I talk about how CBD can be taken. You can read this on your own. Next. And it's interesting is that and I'll come back to what I was telling you here in a second, but with CBD, it's commonly thought of as treating chronic pain, childhood, epilepsy syndromes. The only true use that the FDA has approved CBD for is Epidiolex, which contains CBD, and this aids patients that have epilepsy. Okay, next slide. And here we talked about the 2018 Farm Bill. Okay, next one. Now let me make some distinctions here, and then I'm going to get off CBD and cover just a couple of things on the FDA. The Farm Bill only legalized products derived from hemp that have this really low volume of THC, and there you go. But the FDA commissioner said, well, that's very well and good, but we here at the FDA, we still have the authority to regulate products containing cannabis and cannabis-derived compounds. What does all this mean? Well, it may be legal to sell CBD derived from hemp that's produced in accordance with the Farm Bill, 0.3% or less of THC, depending on the purpose for which it's grown. Up to this point, the only exception that the FDA has allowed is for the Epidiolex. Okay, so going ahead, if you could, Tracy, going ahead to the next major heading on the FDA while I finish up talking about CBD. And so what's happening is that up to now, there's been very little federal enforcement. The feds have pretty much let the states do their thing. And so in many states, thank you, Tracy. I'll get to that in a second. In many states, the law pertaining to CBD is much more liberal than the Farm Bill, than the 2018 Farm Bill. And so in our state, if we as a pharmacy, if we want to sell CBD, then it's important that your healthcare attorney determine what state law says. And in addition to that, let's make sure that we're going to be okay with the state pharmacy board. So as long as the state pharmacy board is okay with us, as long as we're not violating state law, then as a pharmacy, we may or may not decide to take the calculated risk that even if we're not in total compliance with federal law from a practical standpoint, there's not going to be an enforcement action. Okay, now let's switch gears. And I've given you, let's go to the next slide, Tracy. I've given you a whole bunch of slides on the FDA. Now, I'm not going to have Tracy go through any more slides for me because we're running out of time. So but you've got about, I don't know how many slides, 20 or 30 slides on the FDA here you can read on your own. Let me tell you the bottom line, though. Okay. The FDA has jurisdiction over manufacturers. The FDA has no jurisdiction over pharmacies that are engaged in the ordinary practice of pharmacy. However, if the FDA reasonably concludes that Just Pharmacy has crossed that line, that I'm no longer acting as an ordinary pharmacy, but rather I'm acting as a mini manufacturer, then the FDA is going to come in and is going to inspect me. For example, if you got your 501A, 501B pharmacies out there, but if I'm just a regular retail pharmacy, say here in Texas, and I'm out compounding drugs that are commercially available, I've got a problem. Or if I'm compounding a huge quantity of drugs that are not commercially available, but I'm cranking these things out in huge quantities, then I'm going to be looked at. If I am compounding a lot of drugs in advance of receiving the prescriptions, I'm doing this in a big way, I've got a potential problem. Again, you can read these on your own in the slides that I go into minute detail. The point I'm trying to make, though, is this. as a pharmacy, and particularly if all we're doing is commercially available, over pill counters, then the FDA will likely never ever knock on our door. If, however, we are involved to some degree in compounding, then it's likely that during the course of our career we're going to be investigated. And that's okay. That happens. In the slides that you have, you'll see a lot of detail as to how to prepare for an FDA investigation and then how to respond when the FDA investigators walk in unannounced, usually with your state board representative, and say, "Hi, we're here." And they stay on site with us for 2 to 3 to 4 to, or maybe more days than that. And the key is to work it out with the FDA. Just be cooperative, win-win, and then you'll see what will happen. And here are the takeaways, and I'm going to quit. At the end of the investigation, I'm sorry, that's not correct. At the end of the inspection, let's say that the FDA is on site with us for 4 days. On the 4th day, and the inspectors are about to leave, they're going to say to Jeff's Pharmacy, "Here is a form. It's called a 483. This sets out the results of our inspection. Hey, Jeff, why don't you read this and sign it?" No, I'm not going to sign anything. I'm going to be very polite and say, "Thank you. I will take that, and I'll take a look at it, and I'll get back to you." You don't, and so the inspector says, "Well, gosh, Jeff, can you at least read this and verbally give me your thoughts?" Politely, I say, "No, I will look at this after you guys leave." We don't acknowledge anything in front of the FDA inspector as far as the 483. The key then is we don't want the FDA to come out later, a month later, and send us a warning letter. We prefer to avoid that. And so you and your healthcare attorney, you take the 483 and you quickly do a response letter back to the FDA where you give the FDA as much of a victory as you can, as you reasonably can. And also your attorney will then follow up with phone calls with the FDA regional office. Hopefully this will avoid a warning letter. If, however, we do get a warning letter, that's not a scarlet A, a lot of pharmacies get it, then we do the same thing. We get the warning letter, we respond to it, give the FDA as much of a victory as we can, and then we follow up with phone calls. Hopefully, by doing all of this, then it's a way that we can resolve the FDA's concerns, and we can live, and yet we can continue with our business. Okay, Tracy, I've talked way too long, but I've covered the 4 main areas: working with doctors, working with PBMs, a quick overview of CBD, and an even quicker overview of FDA investigations. What I've not been able to cover verbally, you can read this in your slides. Again, your slides are very detailed, so it's not like you can kind of read them like a novel. So with that, Tracy, I'm happy to take whatever questions the folks have.
Wonderful. Thanks, Jeff. So we've got a few questions in the queue. The first one is, how do the PBMs get around FWA, or fraud, waste, and abuse? They are the very model of fraud, waste, and abuse.
I don't disagree. Okay, a couple of things. I don't think I have anger issues, and I'm not a conspiracy buff. The PBMs are, as of today, are about as unaccountable as big tobacco was 25 years ago, and about as unaccountable as pharmaceutical manufacturers were 10 to 15 years ago. PBMs spend a fortune on lobbying and have a lot of influence, both in Washington, D.C. and in our state capitals. PBMs have really smart lawyers who can make what I consider to be credible arguments that what the PBMs are doing falls within a safe harbor or an exception or something that the law allows. And normally PBMs are not caught on the carpet because most pharmacies don't have the money or the desire to get into a full-scale spitting contest. The only credible way, I think, reasonable way, that PBMs can be reined in is through, well, eventually we'll see some federal laws that'll be passed, but it's going to take another decade because of the lobbying efforts of PBMs. However, we are beginning to see states that are protecting their own, that are passing state laws, that are, that are putting handcuffs on PBMs, saying, reining them in, saying you can't be doing what you're doing. Now, PBMs have sued to block the state laws, and I think it's a Rutledge case now that's before the United States Supreme Court because Arkansas passed a law that affected PBMs. PBM said you can't do that because that's preempted by ERISA. Arkansas says no, and then that's worked its way up the Supreme Court. So the short answer is the reason that PBMs have gotten away with a lot of stuff is because they've been able to. They've got the financial ability to do so. They'll be reined in through, in my opinion, eventually through federal law, but in the time being through state law.
Great, thank you. Next question. Are you saying it is legal and okay to pay physicians or provide gifts to a physician in return for patient referrals? And does this apply in all states?
Great question. The short answer is no, you can't do that. Here's what you can do. You can never, ever, ever, ever give the law is crystal clear. Pharmacy cannot give any type of gift or reward to a doctor for referrals. You know, if it's a quid pro quo, Dr. Jones, thank you for the referral, here's a gift. Man, that's just a felony, and that's awful. Can't do that. All we can do with doctors are, number one, we can spend, as I mentioned, $423 on stuff, just marketing efforts during the course of the year, meals, golf games, I don't know, ballet, whatever. We can do that. It can't be tied into referrals at all. It's just marketing. We can also pay physicians for legitimate services, such as speaking for us at an educational event or being our medical director. But if we are conditioning payment to a doctor based on referrals, then that's going to get us into a whole lot of trouble. That's from a federal standpoint. I'm confident in telling you that that this is exactly the same in every state. So the state laws would say the exact same thing.
Thanks, Jeff. And I do note that it is the top of the hour. Jeff indicated he can hang on and address a couple more questions, so I encourage you to hang on the line. But if you've got other places to be, attendees, we certainly understand. Next question was, what if the physician pays over fair market value for the AWV?
Interesting. Probably we're okay. I mean, technically the law says doc's got to pay fair market value for the AWV. If the doc is paying more than fair market value, then I don't see how that would generate any interest or concern by an enforcement agency. So that doesn't really bother me.
Okay, great. Next one, what is the definition of mail order? We are in rural Montana and we mail to our patients in the country.
Great question. What is a definition of mail order? Let me. The definition of mail order is basically whatever the contract says. Often, the contracts define mail order, or the policies and procedures of the PBM that are incorporated by reference into the contract define mail order. If there is no definition of mail order, then we go back to, I don't know, go to Webster's Dictionary or someplace, and this see what it says. Now, what's interesting, rural Montana. Um, I may be Pollyanna here, but I've had some success with PBMs carving out an exception to pharmacies such as the one that just asked this question. In other words, it'd be appropriate for the pharmacy to pick up the phone, call the PBM, and say, you know, you as a PBM, you're not servicing folks out here in western Montana or central Montana. We're going to, we need to be able to mail stuff so these poor old ranchers don't have to drive 150 miles into the pharmacy. Are you okay with that? And we've had some success with that where the PBM will carve out an exception for that particular type of pharmacy that's servicing a rural area. So I don't know. I mean, it's kind of I guess if the pharmacy just ignores the mail order rule and just continues to stick stuff in the mail, I mean, might that be a don't ask, don't tell, look the other way? I don't care, perhaps, but there's still some risk there. I would prefer to at least have that conversation with the PBM.
Okay, thank you. Next one was, we work with a sales company that helps with account management and new business for our LTC pharmacy. They invoice us every 2 weeks. Therefore, they are not W-2 or 1099. How would this be viewed? Is it okay?
I think probably I'd have to have more facts as far as what they're doing for us and how we're paying them. For example, if this outside company, ABC, let's say that it really is not generating business for us, directly or indirectly. Let's say it does more back office, front office, then I don't really care. Then because it's not generating business, I don't really care how we pay it. Now, let's assume, however, that ABC is out setting up accounts for us, whatever that means. I guess that might be the case. The ABC goes out and introduces us to long-term care facilities. Now, if we are paying ABC on a per-hour basis or on a fixed monthly basis or something like that, not tied into the business that we get from these long-term care facilities, then in my opinion, that's low risk. That particular questionnaire, let me suggest, have you send me an email with your question, and then I'll have my assistant set up a phone call. I won't charge you for the call. And let's just talk through it. Let me get some more information from you, and then I'll be able to tell you if there's very much risk.
All right, thank you. Are we able to make a contract with a nursing home that stipulates that if services stop, they would be responsible for the expense of their med card?
Interesting. I think so. So let's talk about this. Let's think about that for a second. Med card. We have a right as a pharmacy to provide a med card. The questioner, feel free to disagree with me on this, but in order to avoid kickback issues, title to the med card remains with the pharmacy, and the facility is directed to only use that med card for the drugs that are dispensed by the pharmacy that provides the med card. Now, if the facility decides we're just going to try to shift all of our patients over to somebody else, and so therefore ABC Pharmacy, the one that provides the med card, we're going to vote you off the island, then I'm perfectly okay with saying to the facility, okay, we're going to come pick up our med card and have a happy life. I think I'm okay with that.
Okay. Do you have time for a couple more?
Listen, I've got all the time in the world. This is important, and I love education. And so you just as long as you can, as long as everybody's interested, and Tracy, as long as you are willing and ready, I'll just answer all the questions in the world for as long as it takes.
Lovely, thank you. Next one was, how are manufacturer coupons legal when it comes to collecting copays? Now we see Medicare Part D coupons.
Yeah, there's a, and I wish I had the, I don't have the legal citation for you, but there's a, under the federal anti-kickback statute, there is, as I forget, there's either a safe harbor or there's OIG guidance, maybe OIG, Office of Inspector General, OIG, that says that these that from a, there's a balancing act, and that is there is an important reason or purpose behind giving these coupons out, because it allows people to get drugs that normally may not be able to afford them, and if they don't get the drugs, then they're going to end up at the ER at 10 o'clock on a Friday night. And so there's a real policy reason to allow these manufacturers coupons. And there is guidance out there that says here's exactly how the coupon program should be implemented. And so I'm fairly confident that the reputable manufacturer coupon programs are in accordance with the OIG guidance. Certainly, there are a number of sham programs out there, and those are the ones that get in trouble.
Okay, thank you. This next one, I assume, is in relation to the prescriber collaboration, the first topic. What if the spouse is the prescriber? Should we not marry or divorce the spouse?
I love this group. Okay, now let me tell you about Stark. Jeff Baird owns Jeff's Pharmacy. My wife, her name is Nikki. Actually, my wife is named Nikki. So let's say that Nikki is a doctor. Well, the law is clear that Nikki cannot refer Medicare or Medicaid patients to Jeff's Pharmacy. Why? Because Stark says she can't. She can refer cash patients and commercial insurance patients to Jeff's Pharmacy unless there's some state law that says otherwise. But she can't refer Medicare or Medicaid patients. Now, there's an exception, and that is called the rural, RURAL, provider exception, that says that if Jeff's Pharmacy is located in small town Texas, in a rural area, then we're just fine. Nikki can refer Medicare and Medicaid patients. Because Stark applies not only to a doctor, such as Nikki, but also to immediate family members of the doctor, such as spouses, children, siblings, things like that. So that's kind of a black and white answer.
Okay, thank you. Just a couple more here.
Sure.
Speaking of incentives, will there ever be transparency on PBMs receiving rebate money from manufacturers to have or prefer their drug on formularies, even though this process is driving healthcare costs in the long run?
Yeah, I believe so, but I think it's going to be a slog, S-L-O-G. I think it's, it took the United States a good solid 30 to 40 years to bring big tobacco to heel. And it took the country a good 25 years to exert some type of control over pharmaceutical manufacturers. PBMs up to this point have been pretty much left untouched. Do I think we'll see transparency? Yes, eventually. The transparency will come one of three ways. Either through federal legislation, which we'll see eventually, but it's, the PBM lobby is going to fight that tooth and nail, and or through state legislation, which if we get a favorable decision in the Rutledge case before the U.S. Supreme Court, then that's going to really help, or lawsuits. So much of change that we've seen in the United States over the years, particularly with tobacco, for example, has resulted from lawsuits. And so, if we have some plaintiffs that are willing to pay attorneys, and or if the attorneys are willing to take this on the contingency fee basis, then we may see some court orders, some judgments that force PBMs to open up and become transparent. So yeah, that's how I see it.
Okay. Next one. So how does CVS mail out prescriptions to patients? Would this not be mail order?
It is. But CVS is own, and I don't have the organizational chart in front of me, but CVS, Caremark's the PBM. CVS is owned by Caremark. I think that's right. I think that's right. Anyhow, you have the PBM, Caremark, is the one that allows pharmacies into network. And so what it is saying is, okay, we have two networks. I know I'm oversimplifying this, but we have two networks. We have a retail network, and we have a mail order network. Now, the retail network, we're going to open that up to a whole bunch of people, but we're going to really limit their mail order. The mail order network we're going to allow only a few pharmacies, the primary one being the one that we own, which is CVS, and then we might allow a few others. So it's just kind of this closed loop. That's how CVS, so absolutely CVS is mail order, but it happens to be owned by, or it owns the PBM, and so therein lies the connection. And you got the PBM saying, this is my party, and here's who we're going to allow to play. And if you don't like it, that's fine. Go to another PBM. That's how it works.
Okay. I think we'll take one more, and then Jeff, I'll just email you the questions that we didn't get a chance to answer, and we can reach back out to those.
Let's do this. Is there a bunch of questions that...
There's four more in the queue.
Yeah. What we'll do is the ones I'm not able to answer now, email those to me, then I'll prepare a mini white paper or FAQ and send back. I will answer those I'll answer those questions in writing, send it back to you, Tracy, then you can send that out to the attendees.
That sounds perfect. Okay. Well, then we will cut it off there, knowing that we'll be able to get these additional questions answered. Jeff, I wanted to thank you for sharing your expertise with us today, and for weathering some of the technical difficulties that we experienced. We certainly appreciate your support of independent community pharmacy and that of AAP. And again, thank you to Return Solutions for their generous financial contribution. As a